In Ontario, administrative disputes surrounding elder abuse in long-term care facilities, specifically the Southbridge care homes litigation, present a highly specific forensic environment. When these civil disputes escalate, a stark power asymmetry emerges, as seen here with the deployment of Ontario provincial police officers and transport vehicles. Facility administrators invoke criminal trespass notices against family advocates, effectively shifting healthcare oversight into the realm of law enforcement. This creates an evidentiary deadlock. An advocate files a report. The institution issues a counter-allegation. A judge is left to decide entirely without corroborating witnesses. Resolving this deadlock hits an immediate structural wall at the highest level of Canadian law, the Supreme Court's evidentiary gatekeeping. Under the common law rule established in R.V. Bayland, Canadian courts maintain a rigid hostility toward expert testimony that appears to assess witness credibility. The law dictates that a judge or jury is the sole arbiter of who is telling the truth, strictly prohibiting any evidence classified as oath-helping. Historically, the judiciary categorizes scientific attempts to measure truthfulness in the exact same manner it views the vintage polygraph machine as a human lie detector that attempts to usurp the judge's role. Any attempt to introduce computational text analysis depends on a highly engineered legal blueprint to survive threshold admissibility. The proposed scientific solution for the Southbridge corpus relies on computational psycholinguistics, specifically utilizing the Linguistic Inquiry and Word Count software, or LIWC-22, to analyze 24 sworn statements and official communications. Before a judge even looks at the data, opposing counsel will likely demand exclusion under the White-Burgess standard. They will point to the dual role of the principal researcher, who serves as both the data analyst and an active family advocate, alleging a fatal conflict of interest. The legal counter-strategy relies on the specific doctrinal language of White-Burgess. The test is not whether a perceived bias exists, but whether the methodology structurally prevents that bias from infecting the data. We erect an epistemological wall, relying strictly on automated algorithmic extraction to separate the researcher from the data. This diagram shows how the 24 evidentiary documents are processed. Qualitative text is fed directly into the LIWC-22 engine, generating 3 output vectors. By utilizing standardized dictionary extraction, the methodology ensures mathematical reproducibility, down to the decimal point. Because human interpretation is bypassed during data extraction, this algorithmic determinism shifts the dual-role concern away from threshold admissibility. It satisfies the court's requirement for nonpartisan assistance. Once the conflict of interest threshold is cleared, the evidence must navigate the 4 foundational pillars of the R.V. Mohan framework, the primary gatekeeping test for expert testimony in Canada. The most perilous of these pillars requires an absence of an exclusionary rule. We must legally differentiate the text analytics from the forbidden polygraph test. The legal pathway relies on the precedent set in R.V. Marquardt. In that ruling, the Supreme Court clarified that experts may testify on the psychological and structural factors accompanying human conduct, provided they do not opine on ultimate credibility. To satisfy Marquardt, the analysis is rooted strictly in cognitive load theory. In high-stakes legal environments, fabricating or strategically hedging a narrative consumes immense executive function. When an author constructs an inauthentic or guarded statement, their cognitive resources are occupied by formulating plausible details, monitoring consistency, and suppressing truthful facts. The mental machinery experiences acute, invisible strain. This cognitive overload manifests structurally on the page. The author unconsciously engages in linguistic disgracement, marked by a measurable suppression of first-person pronouns like I or me, paired with a surge in conditional hedging terms like should, would, or could. The expert is measuring objectively verifiable syntactic structure and the resulting cognitive load. By providing circumstantial data on the drafting process, rather than declaring the witness a liar, the evidence circumvents the Bayland exclusionary rule. The next Mohan pillar is necessity. The trial judge will inevitably ask why an expert is required to evaluate witness statements that the judge can simply read. The first argument for necessity addresses the scientifically documented fallacy of intuitive credibility assessment. Decades of forensic psychology demonstrate that humans, including trained judges, operate at roughly a 54% accuracy rate when attempting to detect deception. The second argument relies on the cognitive invisibility of macrolinguistic structures. Psychological distancing and cognitive load manifest almost exclusively in junk function words. When reading a dense block of witness text, a judge is primed to focus on explicit events. Critical function words, highlighted in red, operate as structural glue. Because these are processed unconsciously, the human brain ignores the sheer volume of data. A reader is biologically incapable of tracking these microchips manually. Therefore, the computational analysis is strictly necessary. The expert acts as a semantic tour guide, extracting invisible text analytics that fall outside the ordinary experience of the trier of fact. The final necessity argument rests on the mathematical impossibility of intuitive cohort benchmarking. Consider the specific text in question. Two sworn witness statements submitted simultaneously by the primary target witness, Jennifer Linton, detailing separate incidents in September and July. This chart maps the 24-document corpus baseline. Extracting Linton's communicative posture reveals a severe statistical anomaly. Her authenticity score sits at 7.76, yielding a z-score of -4.74. As the data confirms, this represents a less than 1 in 100,000 probability that this degree of linguistic guardedness occurred by random chance. A human adjudicator reading a stack of emails cannot mentally compute standard deviations or multivariate chi-square probabilities. Algorithmic intervention is the only method to prove this anomaly exists. After satisfying the Mohan criteria, the evidence faces the final, discretionary hurdle, the judge's gatekeeper analysis. The judge must weigh the probative value of the data against its potential prejudicial effect. To prevent unverified science from confusing the trier of fact, Canadian courts apply reliability frameworks to evaluate the scientific validity of the underlying methodology. This matrix details the empirical traceability of the psycholinguistic analysis. The center column confirms that the methodology meets reliability standards, maintaining a forensic accuracy rate exceeding 70%. By converting qualitative text into reproducible z-tests, the methodology demonstrates zero algorithmic extraction error and relies on a globally peer-reviewed architecture. Because the expert strictly bounds their conclusions to cognitive load, never claiming absolute truth, the methodology proactively addresses concerns regarding judicial misuse, aligning the evidence with courtroom standards. The methodology offers mathematical certainty to resolve an otherwise intractable evidentiary deadlock. This high probative value justifies its admission under the gatekeeper analysis. With the legal theory secured, the data can be applied directly to the physical stakes of the Southbridge care homes litigation. These conclusions address witness incredibility and institutional retaliation. Data shows a significant surge in cognitive hedging during the primary witness's counter-allegation, p equals 0.001. Additionally, analysis isolated a significant decay in the administrator's authenticity, correlating with the Trespass to Property Act, p equals 0.042. These granular metrics intersect with broader provincial policy discussions happening at the Legislative Assembly of Ontario. They provide empirical evidence regarding the criminalization of healthcare advocacy and legislative frameworks like Vula's Law. When computational psycholinguistics is meticulously mapped to the Mohan blueprint, it isolates narrative guardedness. It transforms invisible institutional retaliation into mathematically objective evidence, providing a pathway to resolving evidentiary deadlocks where traditional intuition fails.